All right, good morning and welcome to the 294th District Court. My name is Chris Martin. I'm going to call this morning's criminal docket. When you hear your name, please say present or here. Juan Wilkins. Timothy Richardson. Angel Berry, Angel Berry. Jason Jones. Mario Martinez. Alyssa Rodriguez. Michael Tuff. Gilberto Jimenez. All right, is there anyone else in the courtroom your name's not been called? All right. Mr. Lewis, if you and Mr. Wilkins are ready, I believe we have our Spanish interpreter available for witness testimony. I'm going to go ahead and bring in the interpreter. Morning, Holly. How are you today? Oh, doing fine. Doing just fine. All right, before I call the case, I'm going to go ahead and swear you in on the record. Raise your right hand and state your name and your license number. Ms. Bill, do you solemnly swear or affirm that you will make a true translation of the statements of court, the questions of counsel, and the testimony to be given by the witness in the matter now on trial to the best of your skill and judgment, so help you God? All right. I'll go ahead and we'll get our witness set up here and let you get on in communication.
Your Honor, before we go on record, I have submitted electronically, I believe, the paperwork. I want to make sure the court has received that. If there's
You submitted a what?
an electronic version of the paperwork, I'm not sure if the court has received that or not. I can't tell if it's done. So.
Sí.
No, sir, I've not received any electronic papers.
A few minutes ago, clicked on everything. It didn't show that it went through, and now the internet is treating me badly. Can we do that manually? We've already gone through the paperwork. I just want to make sure the court's.
Well, if you've already done it electronically, let's just figure out the electronic issue. But we are under a time constraint because Ms. Bill, our interpreter, is only available, I believe, until for another about 14, 15 minutes. Correct, Ms. Bill? She's indicated to us. Is this victim impact testimony or is this in conjunction with the open plea?
Well, Your Honor, it's actually kind of a bit of both. Fact of the matter is we've included a stipulation of facts, and I wanted a moment to speak with Mr. Lewis to make sure that that was covered properly for the court's understanding. If we were not in agreement, then certainly I would need to have the witness testify to the instance.
I think you and Mr. Lewis want to converse on that.
If we may, just very briefly here, I think once he's through with that.
Sure, up there.
Thank you for that opportunity, Your Honor. After conferring with Mr. Lewis, they are in agreement with the stipulation of facts. So I think this really would be more of a victim impact / I believe we will be requesting a restitution hearing as well to address those matters beyond the scope of today's hearing.
So what I would like to do in order to make sure that we have the assistance of Ms. Bill is take things a little bit out of order. I go ahead and allow the witness to give the testimony, and then we'll take up the actual open plea. Is that fair, Mr.
That's
Lewis?
fair, Judge.
Okay, all right, so I haven't stated it, but we are now on record in cause number CR 24-123, State of Texas versus Juan Miguel Wilkins. So at this time, Mr. Hernandez, if you would, do you have any questions for the witness, and can you ask her questions and identify her for the record and let her give her testimony?
Yes, Your Honor, and that is that specifically for the victim impact portion, or is it evidence with the case?
Whatever it is that you all need.
Okay, as I stated, since Mr. Lewis is in agreement with the stipulation of facts, I don't think we need to delve or really spend a whole lot of time on the factual basis. If Your Honor would like me to request victim impact information of her at this time to make the best use of the interpreter, we can certainly do that.
Yes, sir. Let's do that.
All right, thank you very much. Good morning, Ms. Mayra Flores. Would you please state your full name and spell your last name for the court report?
Mi nombre es Mayra Azucena Ramírez Flores.
And can you spell your last name for the court reporter, please?
Ramírez es con Z. ¿Lo quiere deletrear?
Flores? If you can
Con S.
spell Flores, please.
Flores.
And Ms. Flores, I'd like to talk to you about an incident that happened on Friday, November 10th of 2023 at approximately 9 p.m. Do you remember that evening?
Sí.
And where were you on that evening?
Íbamos de camino, pero era, me parece, de rol. Es que no me sé bien las direcciones.
And where were you driving to at that time?
Íbamos para un casino, pero no sé bien cómo se llama el lugar.
And were you driving the car at that time?
No, era mi patrón quien lo llevaba.
And where were you seated in that car?
En la parte del copiloto.
And around that time, what do you remember happening to you specifically?
Pues el señor del tráiler iba a la par. Nosotros veníamos un poco por atrás.
And what happened with that person in the truck?
El señor movió hacia nosotros el tráiler. Entonces mi patrón silbó, se regresó a su lugar, el trailero. Después a nosotros al cruzar a la par de él,
Yes, ma'am.
el claxon del carro para que nos alcanzara a ver el señor.
And what happened as you passed the truck?
Yo solo sentí como que botó algo del tráiler y me empezó a arder mucho mi pie. Entonces le dije yo a don Eswar que algo había botado, que me estaba ardiendo mucho mi pie, me estaba doliendo, que se parara, por favor.
And after you stopped, were you able to determine what happened to your foot?
No, solo tomé mi mano, me agarré y la levanté y me dijo él que pudo haber sido un disparo, una bala.
Did the person who was driving the truck pull over at that point as well?
No, fue cuando mi patrón le empezó a mover para un lado y para otro la camioneta para que él detuviera.
But he did stop at some point.
Sí, se detuvo un poco más adelante.
And was the police called?
Sí, mi patrón desde que vio que había botado algo, intentó estar marcando.
And did you go to the hospital that night?
Sí, esa noche me llevaron al hospital.
And did you determine what had happened to your foot?
Sí, de hecho, cuando llegaron los de la ambulancia, la bala estaba dentro donde estaban mis pies.
And how has that injury affected your life?
Pues bastante. No he podido trabajar bien.
I may approach some.
You may.
What kind of work were you doing at the time, Ms. Flores?
He trabajado en limpieza de casa.
That require you to be on your feet a lot?
Sí, y tengo que subir escaleras.
Have you been able to assume a normal working schedule since that day?
No,
How has this impacted the rest of your life?
pues mucho porque tengo una niña en México y mi mamá también depende de mí.
And Ms. Flores, have you calculated what the sum that you are out of in terms of lost wages or economical impact that you've sustained as a result of this injury?
No exactamente, pero sí es un aproximado.
And would that include also payment of medical bills that you've sustained?
Pues en sí, prácticamente me he curado sola. No he tenido atención médica como tal.
And what is that figure that you've come up with that you've lost as a result of this event?
Pues quisiera pedir que se hiciera cargo y pues por daños y perjuicios en la cantidad de 25,000 a 30,000.
And Ms. Flores, can you tell us how much you were earning in salary a month for doing the house cleaning services?
No, cada mes un aproximado, no.
What about a weekly basis?
A la semana gana 850.
$850 a week?
Así es.
Mr. Hernandez, maybe a final statement by her regarding the impact of the crime.
Yes.
I think we're about to expire on our time.
Yes, sir. Ms. Flores. What are your thoughts on what should happen as a result of this event? And what do you think that Mr. Wilkins should be subjected to as a result?
Pues ahora sí que quiero que pues que se haga responsable.
Anything else? Flores, anything else?
Bill, I think that the camera on the witness stand may have disconnected. Just a moment, it may pop back on. Just will you go ahead and address her and see if she can still hear you. I'm not sure that she may still be able to. No. Okay, Ms. Bill, is it time for you to go?
Sí.
Go ahead. Flores, do you have any final statements about how the offense has impacted you as a victim?
Pues solo eso y el miedo que tengo.
Mr. Lewis, any questions?
No questions, witness judge.
All right, thank you, Ms. Flores. You may step down. What's your step, please?
Gracias.
All right, thank you, Ms. Bill. I know that I may have kept you over. I appreciate you being here. Sorry for the delay. Yes, ma'am. Have a good day. All right, council, remind me, did we do the, we didn't do the paperwork at the last, we didn't do any kind of plea or admission of guilt at the last hearing, correct?
Your Honor, we started with admission of guilt. We were going to the point of taking facility by the state. At that moment, Mr. Wilkins withdrew.
Okay, that's what I needed to recall. Thank you, Mr. Lewis.
Additionally, Your Honor, there was a pre-sentence investigation, I believe, that was completed in this case.
Correct.
So that's also before the court.
Mr. Wilkins, sir, if you'll raise your right hand, I'm gonna place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
All right, you can lower your hand. And you can go ahead and have a seat. Your name is Juan Miguel Wilkins, is that correct?
Yes, sir.
And Mr. Wilkins, are you a United States citizen who
Yes.
writes and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No, sir.
All right, in this case, you are represented by your attorney, Mr. Christopher Lewis. Are you pleased with Mr. Lewis and his legal representation of you?
Yes, sir.
Do you have any questions about any of the paperwork that you've read, and signed today that's part of your open plea before the court?
No, sir.
And Mr. Wilkins, you understand that you are charged by indictment with an aggravated assault with a deadly weapon that does carry a potential range of punishment of not less than 2 years in prison up to a maximum of 20 years in prison and a possible fine to exceed $10,000.
Yes, sir.
Mr. Lewis, do you believe that Mr. Wilkins is competent to enter into an open plea agreement before the court?
I do, Your Honor.
You explained to him his rights as they pertain to this case, and you believe that he understands them and is entering into this agreement intentionally, knowingly, and voluntarily.
I have explained that to him, Judge, and I do believe he is ready to enter this plea.
So, Mr. Wilkins, at this time, I would ask you, how do you plead to the second degree felony offense of aggravated assault with a deadly weapon? Are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes, sir.
And Mr. Wilkins, has anybody threatened you, forced you, or pressured you to plead guilty in court today?
No, sir.
The court will accept the defendant's plea of guilt. Mr. Lewis, is there any objection to the stipulation of evidence that's been offered by the state to support the plea?
There are not, Judge.
All right, then the stipulation of evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state, and the court has reviewed, or the court has received rather, the victim impact statement that was provided by Ms. Flores also in writing. She completed that in Spanish, so I'm going to have that translated before I return that to you. Is there anything further than that, and also the court having already heard the oral testimony of Ms. Flores?
No, Your Honor, thank you.
Anything further from the defense?
Yes, sir. Judge, at this time, I'd like to call Mr. Wilkins.
Mr. Wilkins? Well, considering your testimony, just speak up loudly and clearly and one at a time. Allow the attorneys to finish their questions before you give any answers, so that my court reporter can take down what each one of us is saying. Okay?
Yes, sir.
Lewis, go ahead.
Yes. Mr. Wilkins, briefly, can you explain to the court your current occupation?
I'm a truck driver,
How long have you been a truck driver?
34 years.
Okay, and in November of 2023, you were operating as a truck driver at that time?
Yes, sir.
And you recall the incident that you've heard during the victim impact statement, correct?
Yes, sir.
And from your point of view, what were you doing at that particular time?
I had just left the Loves at exit number 40. Was emerging into traffic, and there was a 18-wheeler in front of me, and he was going slower than what I was. So when we got on the highway, got up to speed, put my signal light on, and went around him. And the truck that I drive it takes a while for it to get up to speed, but I was going faster than the truck that was, so it took just a little bit longer to pass the vehicle. And once I got past the vehicle, I put my signal lights on, and he flashed his lights for me to go over. But then that's when the other car behind me cut me off to go around.
And how long, before this incident, how long had you been a truck driver?
How long have I been driving?
How long were you a truck driver before this incident happened?
Before this incident happened? Like I said, I've been driving over 30 years.
So when this happened, did you feel it was on purpose, or you got cut off on purpose, or you feel it was an accident, or what did you feel at that particular time?
Well, at the time, I felt like, it was purposely done that he cut me off. I guess because, like I said, my truck goes slow, and people get upset sometimes when they behind us. And like I said, when I got past the truck, I proceeded to go over, but I couldn't because I saw him coming. So I had to swerve to move out the way to keep from hitting that car.
So is it fair to say that you might have been extremely upset or tempers had flared at that point?
I mean, I wasn't upset, but I flashed my lights at him to let him know that, hey, you almost hit me, so that's the reason why I did it. Flash my lights at him.
And were there any other gestures or any other type of dispute that happened as a result of you flashing your lights?
Yeah, like I said, when it flashed my lights, he proceeded to brake check me. And that's
Wait, just so everyone understands. You say brake check. What do you mean?
so that's when someone gets in front of you and slams on their brakes as a result of them trying to get you to run into the back of them. And I slowed back, and I blew my horn at them, let them know, hey, you about to cause an accident, and that proceeded for a few minutes more, and then he drove off.
And he drove off, so what did you do next?
I got in my lane and stayed there. I was driving in my lane.
How did you two come into contact again?
For some reason, he slowed down again and came back. My truck only does 72 miles an hour. So they're governed at 72. And so, like I said, he drove off, but then he slowed down and came back and proceeded to try to run me off the road. Again, I was in the right lane. Wasn't in nobody's way. Had already passed the truck behind me. And when he, again, he just started trying to run me off the road. I'm like, okay, what's going on here? I'm not understanding what's going on. And he got in front of me. He came beside me, was trying to gesture me to run me off the road. And I'm like, okay, what's really going on? So I slowed back. And he did the same. I'm like, okay, what's really going on? This never, my 34 years of driving, not this. I never had this type of aggression, to go on, you know.
And to be fair, were you upset at this time as well?
Well, it did upset me, because again, I'm trying to figure out, okay, what's going on? You already done cut me off. You brake checked me. Then you drove off. So now I'm trying to figure out, why are you coming back to do this? You know, it wasn't called for. It was, you know, that action is not called for you to come back to me to try to start running me off the road. So yeah, I'm upset, you know, and you know, a bit frightened at the same time, because I don't know what's going on. I've never been in a trucking accident. I've never been in a rollover or anything like that. So that's what in my mind I'm thinking that I'm like, okay, if he proceeds to, it's a ditch right here. You know, there's a ditch right here. So I don't know, you know, I don't know what's about to happen.
Now, so you pulled your weapon out, is that correct?
Yes, sir.
And the car next to you never got out of the car or did anything of that nature, correct?
Could you repeat it?
You guys were still driving as you pulled your weapon out, is that correct?
Correct.
And now that you're in a better state of mind than you were that that particular time, why did you proceed to firing your gun into the car?
Well, actually, it was really to scare. It was a pretty much a scare tactic, because at the same time, I'm like, okay, you're being aggressive towards me in a way that, okay, I don't know what's about to happen. If I go in the ditch, I don't know if I'm gonna lose my life. I don't know what's gonna happen. Again, I've never been in an accident before. You know, never been. It's not, and to pull the weapon, it wasn't an intent to hurt or harm anybody, because at the time when that person passed beside me, tinted windows, so I didn't know that there was a person in the passenger seat. So I could not see inside the vehicle at all. So that was, again, was a attempt to frighten, because you know, I'm like, at the time you're being aggressive towards me. Why? For one. And I'm like, you know, okay, why would you, you know, do that? So at the time, it just fear just overtook me, fear. So that was the reason why. It wasn't a reason to hurt, kill, or anything like that. I'm thinking you the only person in the car, so that was the reason why.
Now, knowing all this, if you could take back that particular incident, what would you do different today?
Oh man, probably would just stop the truck and put it on the side of the road, or call 911. That's what I really should have done. To say, hey, someone is out here trying to harm me, or I don't know their state of mind. You know, just to report it. You know, not to do anything that's going to hurt anybody. You know, I mean, again, I've been doing this for over 34 years. Never had that happen before, or anything. You know, and I'm not a violent person. I'm not that person. You know, I go to work, come home, try to support myself. That's basically it. You know, I'm not out here trying to road rage anybody. That's not my intent, you know, to do anything like that.
If we stand in front of the judge, you admit that your actions were reckless that day.
Yeah, it was reckless, stupid, you know. But again, it's, you know, at the time, not thinking clearly, you know, not thinking clearly, and again, fearful, and just reacting, you know, to it, you know, of what was happening, you know, and that was it, you know.
Now, after the weapon was fired and you were eventually pulled over,
Yes.
you misled the police with regard to whether you shot your gun or not. Is that correct?
Yes, sir. Fear again. Just being real fearful. Just panic. That's it.
Well, you panicked, but let's be frank. You outright lied about
Yeah, I
What
did.
happened?
Yeah, I did.
See,
Yes, sir.
do you regret that or?
Oh, man. Every day. Um, that's a constant replay of what I could have done different. Constant replay of, you know, just, you shouldn't have done this. Very, very remorseful. Not a day goes by that I don't think about it, and it just, that night just shouldn't have happened. If I could have done something different, I'd have stayed at home that night, really, to think about it, to go back and I'm not laughing to be arrogant or anything like that. It just shouldn't have happened. That's all, plain and simple.
Prior to this incident, have you had trouble or issues with the law?
Never. No, sir. No, I have. Not doing no name calling or anything, but I have people that are judges, friends, back home, you know. I have people that are in law enforcement that I know of. I have, you know, never done that. I had a family, you know, raising a family and everything like that. So I'm trying to make sure that I'm doing everything right, um, to stay out of trouble, to make sure I can provide for family.
Now, you have children, is that correct?
Correct.
What'd you tell your children about your actions that night?
Oh, I told my daughter. She's here. I told her what happened. Uh, wasn't proud about it. She was calling everybody, trying to figure out where I was, because normally what I do when I get home, I always call her and text her, let her know I made it. That's normal routine. And when she didn't see that, she panicked, and trying to figure out where her daddy was. So, not proud of that. First time.
A couple more questions. You understand how serious this offense is that you're being charged with, is that correct?
Yes, sir.
And then you also understand that although the shot was fired and hit someone in the leg, or Ms. Flores in the leg, you understand it could have been a lot worse.
Yes, sir.
When you play this back in your mind, what could have happened?
Again, man, I went through 10,000 scenarios. Should have stayed at the truck stop. Probably should have stopped and took a nap. Wasn't sleepy, but just should have just stopped and just not driven. I don't know. But again, it's just very sorrowful, and you know, just shouldn't have happened.
What does
Just
the term remorse mean to you?
right now. I mean, then and now and before, just being very sorrowful. Just shameful, sorrowful. Um, yeah, that's it. I mean,
And since then, have you entered in any type of programs or anything to um, get past or try to understand what happened that night?
yes, sir. I see a counselor every Tuesday. Um, we talk about um, that and other, things that go on. Me being a truck driver for 34 years, you don't realize what type of stress that you'll be up under on that type of job because of your responsibility. Um, the term professional driver, we're supposed to be better than the normal drivers that would drive a car. And that's a lot of stress, to try to endure. But on a day-to-day basis, we find a way of doing it. Are we perfect? No. But so that's some of the things that we talk about, the stress part of it, um, talk about the events that happened, uh, I recently was in um, a head-on collision with a guy that was in the wrong lane and hit my truck head on. The fear of that, uh, thank God that we both walked out alive. But just the fear of that, that is a constant thing that I still have to endure, still have to try to um, get past.
And that fear that you felt in your accident, does that help you understand the fear that Miss Flores?
Oh,
Yep.
yes. Yes, sir. I mean, if I could take it back, man, never would have. If I could take it back, I'm not out here trying to harm nobody, man. I'm not here trying to hurt nobody, trying to run over nobody, trying to end someone's life or anything like that. That's not my intent. My intent when I go to work is I say to myself, I come home the same way I left. That's in the truck safely and come back home safely.
Now, I'll kind of wrap up here, but you understand that a lot of people come when they have to face up to something they've done wrong and say, I'm sorry, I'm remorseful, and I was dumb, and kind of the same story that you're telling. You understand that, correct?
Yes, sir.
So in addressing this court and the judge, what makes you different, or what makes this situation different?
It would be, I've never been in trouble before. I've never been in court before, other than a jury duty I've done. I mean, I'm just praying and hopeful that, mercy would be shown. Again, I'm not a perfect person, but I'm just not a violent person. I'm not a person that's out to hurt nobody.
And you've managed to talk to different people in the community who have written letters of support on your behalf, correct?
Yes, sir.
Okay. And would you like the judge to be able to see those items?
Yes, please.
Okay. And Your Honor, this time I'd like to enter exhibit 1. I provided that to the state.
Are there any objections to Defendant's Exhibit 1?
No, Your Honor.
Defendant's Exhibit 1 is admitted.
So Wilkins, as I close at this point, is there anything else you'd like to say on your behalf, or say to Ms. Flores, to the state, and everyone here?
Yeah, I'm so very sorry that incident happened. It was not my intent for any of that to happen. Wasn't aware, but that doesn't excuse the point. But just very sorry that happened, man. Again, if I could take it back, if I could take it back, never would have happened. Wouldn't be here. Just very sorry.
There's nothing further this was at this time.
Pass the witness.
That's what's in.
State.
Briefly, Your Honor, Mr. Wilkins, good morning. You said that you can't change things that have happened, obviously. And you were present when Ms. Flores testified how this has affected her emotionally and
Yes.
financially.
Yes.
You heard her ask from anywhere between $25,000 and $30,000.
Yes.
Does that sound fair to you?
As fair as it can be. Sorry, as fair as it can be.
As fair as can be. Do you think that may be a way to make good on your recklessness from that day?
Yes.
Nothing further, Your Honor. Thank you.
Your Honor, nothing further.
All right, thank you, Mr. Wilkins. You may step down.
I'm shaking because I'm cold. It's cold in here.
Mr. Lewis, I believe that in anticipation of the open plea agreement today, the court had the Community Supervision and Corrections Department complete a pre-sentence investigation report. Did you receive that on behalf of your client?
I have, Your Honor.
Do you have an opportunity to review that? And if so, do you have any requests for additions, deletions, or modifications?
There is nothing we'd like to add or delete, modify, Judge.
Mr. Hernandez, on behalf of the state, any
None, Your Honor. Thank you.
none? The court will review the pre-sentence investigation report. Anything further from either the state or the defense at this time?
No, Your Honor. Thank you.
Your Honor, nothing further from the defense.
Okay, so what I'm gonna do is, I have accepted the plea of guilt from the defendant. The court, is going to take that under advisement at this time. I'm going to review defendant's, exhibits, defendant exhibit 1. And, we will, recess in this hearing, and then, here in just about an hour or so, once I complete some other business, then I'll come back and render the sentence of the court.
Thank you, Your Honor.
Thanks.
We're in recess in this case. And I'm sorry, Mr. Lewis, Mr. Hernandez, I failed to provide you the opportunity. Would you like any kind of closing argument or question from the state, from the defense on what the court should do or should not do?
Your Honor, from the defense perspective, I think you've heard the testimony. My client is deeply remorseful for his actions. I think he's been very clear about that. We understand the seriousness of the offense as well as the potential impact he could have caused to Ms. Flores, the community, or anybody else passing by. He's deeply sorry for his actions. We'd ask, based on his criminal record and or lack thereof, that the court take that into account. We would like a deferred probation sentence in this case in order to allow Mr. Wilkins to show the court who he is. He can complete it. He's employed. He's got the financial wherewithal through his job, working to make sure that he can compensate Ms. Flores for her injuries. And I think he can do well in our community and not be in front of you in a criminal capacity.
Thank you, Mr. Lewis. Mr. Hernandez.
Thank you, Your Honor. I think in light of the fact that Mr. Wilkins has acknowledged his reckless behavior, I think it's knowing behavior as well. It's very clear that this could have ended much more tragically for so many people. I had the conversation with Ms. Flores about the different options available to Your Honor as a part of the sentence to this case, and fully advised her that, you know, any restitution that she's requesting may very well be delayed by a prison sentence, because that certainly would not allow for Mr. Wilkins to continue to pay off things, to provide for his family and provide for the financial obligations of the court. As Your Honor can recall, she testified to the fact that she's just asking that he be held accountable. I think that was her way of saying she just wants that acknowledgement, but most importantly, she just wants to be made whole and be at a point where she was prior to this event, where she was providing for her daughter, she was providing for her mother, and she was keeping up with her bills here as well as maintaining a full-time job. She made the request of a sum of $25,000 to $30,000. Mr. Wilkins said that 25 sounds fair to him. Taking into account, I think, everything that has gone into this case, that may be the best of all resolutions under the circumstances. Thank you.
Prior to beginning this hearing, you indicated that you anticipated requesting a restitution hearing. Is that something that you're still asking the court to do to get a definitive amount or provide evidence to support the claim? What's the consensus there?
Judge, at this time, we would waive that request. I think it's after hearing the testimony and understanding what has gone into that request for restitution, I think we're comfortable with that amount.
Okay, thank you, Mr. Lewis. Anything further, Mr. Hernandez?
No, Your Honor, thank you.
Mr. Lewis, anything further?
Nothing further, Judge.
Okay, all right, then we will recess in this case. I'll be back shortly with a decision.
Thank you, Your Honor.
Do we have any other counsel that's ready?
This one.
That's right. Do you only have Mr. Jimenez today?
Yeah.
This morning, yes. Okay. Mr. Jimenez. Okay. Mr. Jimenez, this is cause number CR 24-210 and 211. State of Texas versus Gilberto Juarez Jimenez. And I show that we're set for status. I think we were waiting on the Court of Criminal Appeals ruling on a dog sniff. Is that correct?
Yes, sir. There was a case that we feel that could be dispositive in this matter. I have viewed the CCA website. It looks to me that the case is set for submission on May the 7th. There was a reply already filed, I believe, about a week ago. So.
Any objection, state, to resetting this?
No objection, Your Honor, thank you.
All right, then let's set Mr. Jimenez. Mr. White, are you available on? Let's just set it May 29th. Court of Appeals may or may not have an opinion issued by that time, but we can set it for status on the next contested docket, which is the 29th. Once he's signed, he's free to go.
Thank you, Your Honor. I'll see you Saturday.
Yes, sir. Mr. Manning, good morning, sir. You ready on Mr. Timothy Richardson?
Yes.
Mr. Richardson, come on up, sir. This is cause number CR 24-187, State of Texas versus Timothy Lance Richardson. Motion to adjudicate. But
Judge, I just learned that Miss Curry was the one that was handling this case. I've not been able to get an offer from her, so I request that we set it for next month's docket.
No objection.
all right, court sets Mr. Richardson for hearing on 5/29. So Mr. Manning, whether the state makes or doesn't make an offer, we'll look to dispose of this case on the 29th.
Yes, Judge. I feel like that concludes my business this morning. Might be excused.
Yes, thank you. Wait, you ready? Yes. Barry? This is call numbers CR 25-61, 62, and 89, State of Texas versus Angel Abel Salazar Berry. And I show that we are set for arraignment today. Mr. Berry, for the record, is in custody of the juvenile detention center. Go ahead, Mr.
That's correct, Judge. Mr. Do you know if Barry Salazar? Salazar? He goes by Salazar. So Mr. Salazar understands the charges. We'd waive formal reading. Enter a plea not guilty to all charges and ask for pretrial setting. Is it definitely like that? Barry Salazar or just Barry Salazar? Okay, and his name is, I think, spelled out correctly, Angel Barry Salazar. So two last names.
What does the indictment show his name to be?
I don't have a copy of the indictment in front of me. Judge. Is that correct?
Angel Abel.
Angel Abel Barry Salazar. Your docket shows Abel or Angel Abel Salazar and last name Barry, but it's Angel Abel Salazar Barry. It's Barry Salazar. We'll get it. Yes.
All right, so in the indictment, it appears to be laid out correctly. Angel Abel Berry Salazar.
That's correct.
Just the docket has it backwards. So, okay. All right, then the court finds that Mr. Salazar, having waived the formal requirements of arraignment, enters his plea of not guilty into the record in each case. Court will set this matter for pretrial hearing. Do you, Mr. Schmidt, by chance know when the next juvenile hearing may be regarding?
Yes. It's May 5th, Judge.
May 5th.
Yes, sir.
All right, so let's set this. We can keep it, let's keep it on the 29th of May. That'd be our next
Yes, sir.
docket like this.
Do you want an afternoon or morning?
Okay. Morning or afternoon? Morning. You need something later than 9? That's fine. Okay. Court sets this hearing for pretrial hearing on May 29th at 9 a.m. each case.
Huh? Canton? Yeah, I think he's going back to juvenile. That's your reset notice. All right. Where's it? Thanks, appreciate it. Jason Jones.
Jason Jamal Jones, CR 21-297. You're on motion to adjudicate. Go ahead.
That's correct, Judge. We've been working with probation department and the DA's office. Mr. Jones has some outstanding fees that he's trying to get attended to. And they've we've asked that, he be reset for status on his, probation fees. I think, he owes like $2,800, give or take. And once we get that paid off, we should be able to resolve it.
Any objection from the state?
No objection, Your Honor. Thank you.
How about, it's a Thursday, but that's my next evidentiary docket, that I think we should set Mr. Jones for, be July 3rd,
July, which one?
July 3rd.
3rd? Yes, sir.
Right, court sets Mr. Jones for status on TA July 3rd, 9 a.m.
Mario Martin.
Mario Martinez, CR 21-178. That on the motion to adjudicate?
That's correct, Judge.
Final I think final setting on that.
Yes, sir. And we've got a resolution with the state. We're gonna ask to set him for a plea for a 1:30 plea time. And he was looking at that your May 29th, if that would work.
Any objection from state?
No objection, Your Honor. Thank you.
All right, court sets Mr. Martinez enters plea before the court May 29th at 1:30.
We're gonna be set stuff. Yeah, I'm not worried. Yeah, we're gonna do it. Where?
Michael Cole Tuff, CR 22-296. Understanding there's a motion to adjudicate and a possible agreement between the parties to extend Mr. Tuff's community supervision.
That's correct, Judge. May I approach?
You may.
And his conditions, we have them in the conditions here to extend him for a year, 17 days in jail.
All right, Mr. Tuff, if you'll raise your right hand and place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you can lower your hand. All right, Mr. Tuff, I see here that there's an agreement between you and the prosecutors wherein you are agreeing to extend your period of community supervision. And also in addition to that, that's an extension for a period of 1 year. You were set to expire on March 7th of 2027. And now your extension would be, I'm sorry, let me back up. You were, no, that's correct, isn't it? It says to begin on March 7th of 2027. That's when you were set to expire. So you're going to be extended for 1 year. Your new expiration date would be March 6th of 2028. As part of that extension, you're also going to be required to pay probationary fees during that time of $60 a month, in addition to any your analysis fees of $5. And also part of that agreement is that you are going to serve 17 days confinement in the county jail. You're going to receive credit for that time that you've already served between June 19th of 2022 and also the period between November 25th, 2024 through December 10th, 2024. Is that correct, Mr. Tuff?
Yes, sir.
And Mr. Tuff, before I consider this agreement, tell me why is it that I should allow you to stay on community supervision?
To show that I've changed and I can go forward without getting in any trouble.
How have you changed?
My ways, I mean, just my ways, just my way of thinking and everything like that.
What's your new way of thinking?
Like handle my business first, don't let my anger override me, make sure I put my business ahead of anything else.
All right, Mr. Tuff, you realize that you've run out of rope.
Yes, sir.
Understand that?
Yes, sir.
This is it. If I approve this, and you don't pay, you don't show up, commit a new offense, you violate any of the conditions of community supervision, all this is gonna be recorded in the system. I'm gonna go back and review it. And I don't want to continue to put someone on probation who's not gonna do what I tell them to do.
Yes, sir.
Understand?
Yes, sir.
All right, court hereby grants the state's motion to withdraw its motion to adjudicate. The court extends the community supervision of Mr. Tuff for a period of 1 year, orders him to serve 17 days confinement in the county jail as a condition of community supervision. He will get credit for the dates indicated in the court's order. And he also will be responsible for paying probation fees and urinalysis fees during that period of community supervision. And also additional costs associated with filing of this motion. All right, Mr. Tuff, you're hereby released to the custody of the Community Supervision Corrections Department. There's no finger. Let's come over here and see them, and they'll get you copies and tell you about what's next. It's all. Ready on Alyssa Rodriguez?
Yes, sir. You
Mr. Rodriguez,
should have the plea in your queue. Alice.
all right, this is cause number CR 18-175, State of Texas versus Alyssa Michelle Rodriguez. Ms. Rodriguez, if you'll raise your right hand, place you under oath. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, Ms. Rodriguez, you were before the court on August 9th of 2018 on the charge of possession of a controlled substance of penalty group 1 greater than 1 grams, less than 4 grams. The court heard the evidence that day. Court followed a plea agreement and deferred a finding of guilt and placed you on community supervision for 3 years, assessed a fine of $1,500. It was during that period of your community supervision that the state of Texas filed its motion to adjudicate and revoke your community supervision. And in that motion, they alleged 1 count. In this case, you are represented by your attorney, Mr. Richard Schmidt. Are you pleased with Mr. Schmidt and the work that he's done as your attorney?
Yes.
Do you have any questions about your plea agreement today and the paperwork that you've read over and signed?
No.
Mr. Schmidt, do you believe Ms. Rodriguez to be competent? If so, that she's entering into this agreement intentionally, knowingly, and voluntarily?
Yes, sir.
Does she waive the reading of the state's motion to adjudicate?
We do waive reading intent for true. I think there's 1 count in my motion.
That is true. All right, so Ms. Rodriguez, I see that your plan today is that you would plead true to the sole count in the state's motion to adjudicate and revoke. I see that the agreement that you have in this case is upon your plea of truth. The DA's office is asking the court to adjudicate your guilt. That means to convict you of the offense based on evidence it's already received. And they're asking the court to assess your punishment for that possession of controlled substance charge at 5 years confinement prison. But they are also asking the court to suspend that sentence today and place you on community supervision for a period of 3 years, and also ordering you to pay your fine, court costs, reimbursement fees, and restitution as part of this agreement. Ms. Rodriguez, is that your understanding of the plea agreement?
Yes.
Right, any questions about anything before we go further?
No.
All right, then Ms. Rodriguez, how do you plead to count one contained in the state's motion to adjudicate? Is that count true or not true?
True.
Are you telling me that that counts true because what they have alleged to have occurred is in fact true?
Yes.
And Ms. Rodriguez, has anyone threatened you, forced you, or pressured you to plead true to that count?
No.
All right, then the court will accept the defendant's plea of true to count one. Anything further from state?
Nothing further, Your Honor. Thank you.
Anything further from the defense?
No, sir.
Right, Mr. Schmidt, any objection to the defendant's waiver of rights and plea of true being admitted in evidence?
No objection.
That is admitted, and the court takes judicial notice of the defendant's judicial confession. All right, court having considered the testimony and evidence, the court finds that Alyssa Michelle Rodriguez has violated the terms and conditions of her community supervision. The court finding count one to be true. Court hereby adjudicates Ms. Rodriguez's guilt on the charge of possession of controlled substance affiliate group 1 greater than 1 gram, less than 4 grams, a third-degree felony. Court assesses punishment within the lawful range of punishment, which is a minimum 2 years to a maximum 10 years. Court assesses punishment at 5 years confinement in the Texas Department of Criminal Justice. Court further suspends that sentence today and places Ms. Rodriguez on community supervision for a period of 3 years. In addition, the court orders her to pay the balance of her financial obligations, including a $1,500 fine, restitution in the amount of $180, court costs in the amount of $433, and reimbursement fees in the amount of $1,400. Ms. Rodriguez, you're hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. I'm gonna have you come forward to be fingerprinted, and then you can meet with the probation.
Okay. Yes, sir. Where's your pen? Oh,
Anything further, Mr. Schmidt?
Judge, I don't recall on Mr. Barry Salazar whether I requested the court find his bonds insufficient on all charges.
We did, I think we did off the record, so the court is signing those
Thank you, sir.
right now.
I think that's all I have.
Stay your hands on it. Going to stand in recess and consider the Wilkins matter. I will return to the courtroom shortly. All right, we are back on record in cause number CR 24-123, State of Texas versus Juan Miguel Wilkins. Mr. Wilkins appeared today before the court on an open plea on the charge of aggravated assault with a deadly weapon. The court has accepted Mr. Wilkins' plea of guilt. At this time, the court has heard the victim impact testimony of Ms. Myra Flores. The court has also taken into consideration the pre-sentence investigation report that was provided to both the state and the defense, in which no objections were made. Further, the court has also considered and reviewed Defendant's Exhibit 1, which was the character letters in the defendant's on the defendant's behalf presented by Mr. Lewis. So the court, having also considered the stipulation of evidence that was provided supporting the open plea in this matter, the court finds that at this time, Mr. Wilkins has not entered into a plea bargain, however, is pleading guilty to the offense in open court for the court to assess punishment. Therefore, Mr. Wilkins does have the right to appeal his case with regards to sentencing today. So at this time, the court having considered those things, Mr. Wilkins, if you will please rise. All right, Mr. Wilkins, the court having considered the evidence, I will say, Mr. Wilkins, that I appreciated your testimony today. And after reconciling your testimony with the other evidence presented in the case, I do find today that your conduct on the date in question was reckless, and it was knowing. It was also violent, and it was also unjustified. I will tell you, Mr. Wilkins, in Defendant's Exhibit number 1, your daughter wrote a very compelling letter on your behalf. Probably one of the best character letters I've ever seen written to me personally. So you should be proud of her for that. I think she was open, honest, and forthright with the court in her opinions of you and what she thought was what the court should consider. So as a dad, I think you would like to hear that your daughter's done well in that regard. So the court is going to hand down sentence at this time. The court hereby finds that there is enough evidence to convict Juan Miguel Wilkins of this offense. The court today will defer a finding of guilt at this time. The court will not convict the defendant of the offense. The court, having found that Mr. Wilkins, having not one criminal incident in his past, there is no criminal history for the court to consider Mr. Wilkins to be anything other than a law-abiding citizen prior to this date. The court will defer a finding of guilt at this time. Will place Mr. Wilkins on 10 years community supervision. In addition, the court will assess a fine in the amount of $5,000 court costs. The court also assesses restitution payable to Ms. Myra Flores in the amount of $30,000. The court orders that the defendant begin paying that to Ms. Flores as a condition of supervision at a rate of $500 a month, beginning August 1st, 2025, and continuing every month until the restitution is paid. Mr. Wilkins, because your conduct was reckless, it was violent, it was unjustified, and also because you were not immediately cooperative with the police, the court is going to order you to serve 60 days confinement in the Van Zandt County Jail as a condition of community supervision, with that jail sentence commencing today. So you'll be taken into custody today, and you'll be released in 60 days. And at that time, you will report to the Van Zandt County Probation Department. Okay. All right. So court having assessed sentence, I'm not sure what the court costs are. They're probably $270, $290. That'll need to be provided by the clerk. So at this time, Mr. Wilkins, you hereby remanded to the custody of the sheriff so he can carry out the conditions imposed by the court. I'm going to have you come forward and be fingerprinted with Deputy Martinez, After that, he's going to take you in. Sure. So, Mr. Wilkins, after your fingerprint, you'll meet with Ms. Burns. She's going to have you fill out some paperwork for your community supervision. And then after that, you'll be taken into custody, okay? Hernandez, on behalf of the state, anything further?
No, Your Honor, thank you.
Mr. Lewis?
Nothing further.
All right, if there's nothing further, then we are adjourned in this matter. Court is in recess till 1:30. All right, we're back on record in cause number CR 24-123. The court, thank you, Mr. Hernandez, for bringing that to the court's attention. It was the court's intention to order the forfeiture and destruction of the weapon that was seized in this matter. Any objections, Mr. Lewis?
No.
Anything further, Mr.
No, Your Honor,
Hernandez?
I appreciate that. Thank you very much.
All right, court is adjourned.
Your Honor.
Hey, he hasn't taken the bench yet.
Yes, Your Honor.
Are you ready on Mr. Cabrera Alonso for?
Yes, sir.
Well, Ollie, you're back. Why so London? Lucky me as well. All right, before we get on the record, well, actually, let me put this on the record. The court has already sworn, Ms. Bill in as a licensed court interpreter. She was sworn on the record earlier this morning, so that maintains for this hearing. If you'll go ahead and we're gonna try to get Mr. Cabrera Alonso set up and we'll see if we can get a line of communication with him.
We are in English. Right?
I'm currently in ships.
Okay.
Excellent, thank you. All right, we are now on record in cause number CR 21-207. State of Texas versus Carlos Cabrera Alonso. And Mr. Schmidt, is Mr. Cabrera entering a plea agreement today?
Yes.
All right, Mr. Cabrera, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God. All right, thank you, sir. You can lower your hand. All right, Mr. Cabrera Alonso, are you a United States citizen who, I know you don't speak English, but are you a United States citizen?
No.
And so, Mr. Cabrera Alonso, do you understand that any plea in this court today may have a legal effect on your status within this country, including possible deportation and a barrier to re-entry into the United States?
Hey.
In this case, you have been represented by your attorney, Mr. Richard Schmidt. Are you pleased with Mr. Schmidt as your attorney and the work that he's done?
Hey.
Do you have any questions about the paperwork that you have read and signed today that is your plea agreement?
No.
All right, Mr. Schmidt, do you believe your client to be competent today? And if so, have you explained to him his rights as they pertain to this case?
I have, yes.
And do you know, has Mr. Cabrera Alonso ever been diagnosed with a mental condition?
Not that I'm aware of.
All right, Mr. Cabrera Alonso, you appeared previously in this court. Paperwork up here. Don't see the motion to revoke. Give me just 1 second. I'm gonna have to pull up the case. Mr. Schmidt, do you have a copy of the motion to revoke there with you?
I do.
That's okay. Just, you may have to refer to it, since it's not part of the,
And Judge, for the record, I have gone over that with Mr. Cabrera. He understands, we intend to waive formal reading of that and enter a plea of true.
I'm still gonna need to refer to it, so just stand by for just a second. All right, Mr. Cabrera Alonso, you appeared before the court on January 27th of 2022. You pled guilty to the state jail felony offense of unlawful use of a criminal instrument. The court heard the evidence that day. The court considered the evidence in your plea agreement. The court assessed your punishment at 18 months confinement in the state jail division of TDC. The court also fined you $4,500. It was during that period, or it was during that hearing that the court also suspended that sentence and placed you on community supervision for a period of 4 years. It was during that period of 4 years that the state had filed what appears to be October 15th, 2024, this motion to revoke your community supervision, and they have alleged what appear to be 16 separate counts of violations. Have you had enough time to review the accusations against you with your attorney, Mr. Schmidt? All right, Mr. Schmidt, you said your client does waive the formal reading of the state's motion to revoke and intends to plead true to all counts alleged.
Yes, sir.
All right, then, Mr. Cabrera Alonso, at this time, I would ask you, how do you plead to counts 1 through 16? Are those counts true or not true? Yes. And Mr. Cabrera Alonso, are you telling me that all of the allegations in that document are in fact true? Because that is true. You're not just saying that is true to get a certain plea agreement. Am I correct? Yes.
Yes, cierto.
And Mr. Cabrera Alonso, I see that upon your plea of true, the agreement today between you and the state of Texas is that you would, your community supervision would be revoked. Your sentence would be assessed at 12 months confinement in the state jail division of TDC. You would also be responsible for paying the remainder of your financial obligations, which includes a fine. And you would receive credit toward your sentence for time that you have spent in jail on this cause. Mr. Schmidt, what is the credit time that he's entitled to?
308 days, Judge.
308. So Mr. Cabrera Alonso, you would receive 308 days credit towards your sentence for the time that you've already spent in jail on this cause. Sir, is that your understanding of the plea agreement and what you're asking the court to approve today? All right, Mr. Cabrera Alonso, the court having considered your pleas of true to each count as alleged finds that each count to be true. The court will follow the plea agreement today. And before I do that, Mr. Cabrera Alonso, has anybody threatened you, forced you, or pressured you to plead true to any allegation in court? No. Very well. The court then does accept the plea of true to each count as alleged. The court finds each count to be true, finds that the defendant has violated the terms and conditions of the community supervision. The court hereby follows the plea agreement today, revokes the community supervision of the defendant, assesses his punishment to the State Jail Division of TDC at 12 months confinement. Further, the court orders him to pay the balance of his financial obligations, which is a fine in the amount of $3,650. The court awards Mr. Cabrera Alonso 308 days credit towards his sentence for the time that he's already spent in jail on this cause. Sir, you are hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. When you do get out of prison, if you're not deported from the United States, then you are obligated to report to the county courthouse and repay the remainder of your financial obligations. I'm gonna have you step over with a deputy to be fingerprinted. Do you have any questions before we conclude your hearing?
No.
All right, thank you, sir. Step over to be fingerprinted. All right, do we have any more requirement for Ms. Veal? Is that all?
That's all, Your Honor.
All right, again, Holly, thank you so much for your help. Very, very helpful to us. Yes, ma'am. Until next time. Mr. Schmidt, who's next for you?
Brandon Creel.
Mr. Creel, you'll come forward. All right, this is cause numbers CR 23-158, CR 24-206, State of Texas versus Brandon Ashley Creel. All right, Mr. Schmidt, what are we doing today?
Judge, we did have an agreement with the state. Mr. Hartwell informed me yesterday evening that that agreement had to be withdrawn. We are asking for a reset so that we can go back and hash out the shortcomings of our agreement.
You want me to set him for a final hearing on May 29th?
I'd like you to set him for a hearing on May 29th. Doesn't have to be final necessarily.
All right, well, we're gonna split the baby. Court will set him for May 29th for a final hearing, so I don't want him sitting in jail while we're trying to make up our minds, so. He'll have to decide what he wants to do on the 29th. Otherwise, we'll go forward with a hearing.
And Your Honor, just for the court's benefit, I think we're still close. A couple of legal technicalities that we have to work out is the main problem.
Okay.
Michael.
Who do you want next, Mr. Schmidt?
Michael Whitten.
This is State of Texas versus Michael Joseph Whitten, CR 24-9. Any announcements, Mr. Schmidt?
Yes, sir. We negotiated with the state and I think we're pretty close. I spoke with Mr. Whitten today for quite a while during our break, and he's provided me with some additional information that I think may change the state's position a little bit. And I asked Mr. Hartwell at lunch if he would agree to resetting for a final, one final, and give me an opportunity to meet with him and share the information that I have. So we're asking for a 5/29 final hearing date.
And I'm sorry, I may have missed it. What was the reason? I think I had a separate final today. What was the reason we couldn't finalize it today?
Well, I think, I wasn't aware that you were set for a final, but I'm sure your docket says what it says. I spoke with Mr. Whitten and, he provided me with some information from some third parties. And I think that if I share that with Mr. Hartwell, it will change the nature of our agreement. And I just need an opportunity to do that. That's why we're asking for an additional setting.
Chartwell, are you interested at all in receiving that information? If you're not, we'll go forward today. If you are, then I'll reset it.
Yes, Your Honor. I don't know what the nature is, so I'd be interested in learning what it is. We have an agreement in place. It could move me from that agreement. It may not. Me and Mr. Schmidt have briefly spoken about that.
Okay. Court will set Mr. Whitten for second final hearing on May 29th. So on May 29th, if we don't have an agreement one way or the other, then I expect the state to move forward with their motion. Who's
This
next?
Keith Pryor.
This is cause number CR 15-322, State of Texas versus Keith Pryor. Go ahead, Mr. Schmidt.
Judge, I think, we're still working with the state, but the state has got some documents that they've sent off for. So I think we're mutually not ready to proceed. I think Mr. Hartwell might jump in and agree with me on that.
That's correct, Your Honor. We're still waiting for some documentation from out of state to come in.
All right, court will set for a final hearing May 29th at 1:30.
Yeah.
All right, who is this? Mr. Holmes?
This is Gerald Holmes, yes, sir.
This is cause number CR 24-55, State of Texas versus Gerald Alexander Holmes. Motion to revoke. Go ahead.
And Judge, I'm sure the court's aware that, I guess it was 5 or 6 days ago, the court, I don't know if it was sua sponte, but without hearing, I found Mr. Holmes' bond insufficient for some issues that occurred, I believe, at the probation department. At this point, I need time to investigate those things as well as the MTA and talk to the state.
Yes, sir, you are correct. Court did that on its own motion. Court hereby sets Mr. Holmes for motion to revoke hearing on May 29th at 1:30.
Right.
Who would you like next?
This is my final case. It's Corey and Fulbright. We're prepared to enter a plea. You should have the documents. I would tell the court, we have not received supplemental admonishments on him. All the other paperwork is signed and submitted, so I'm not sure if you want to recall him until we can get those.
You're just needing the chapter 62.
Yes, sir, chapter 62. Also, the state, part of our agreement is to enter a plea on the burglary of a building, and that's going to require a restitution hearing in the immediate future. So we'll have to reset him for that as well. So we will be coming back. And I think that we're taking about 45 days for transfers at this point.
You said transfers for what?
Transfers to catch a ticket to the TDC is usually about 45 days or more.
All right, so you want to enter a plea, have him enter a plea on the remainder of these cases, including the burglary of a building, but then also to reset it for restitution hearing. But
Yes, sir.
But we're missing the sex offender admonishments.
That's correct. We have, you should have in your queue all of the plea packets for 4 cases. We're missing the admonishments, so we probably need to either execute those now or contemporaneously with the plea. I can do that after the plea if you like. I'm not sure that the law requires it, but
Well,
it has to be done.
yeah, he needs to be admonished at the time of sentencing, and the law requires me to provide a copy to him. And so that's going to be in cause number CR 24-133. Is that correct? Is that the only one with the
No,
admonishment?
sir, there's admonishments in 133 and
138, 139.
that's correct.
Okay. All right. So, Mr. Hartwell, Mr. Hernandez, if you can direct your office to prepare a separate set of sex offender admonishments to Mr. Schmidt or Mr. Fulbright on those 3 cases, then we'll recall him up after I get those in my inbox.
Yes, sir.
Are you ready to do Mr. Guidry's?
Yes, we can do that.
Good afternoon, Judge. Can you hear me?
Yes, sir. I can hear you just fine. Can you see and hear me? And can you also see your client?
Hold on. I see you, Your Honor. I don't see the client. I'm actually in, just stepped out the courtroom. I'm in trial in Dallas, but I told the judge and he allowed me to step out to talk to you.
Okay, good.
Yeah.
And you may have
I don't
swiped
see
left.
Mr. Warren. Oh, okay.
You want to
Yeah.
swipe?
Yes, I see him.
All right, I'm looking through, I don't think I've received any plea papers on Mr. Ward.
We did everything. I know Mr. Hartwell sent everything online, and he signed it. He signed it. PDF. He signed it, and I guess it was rerouted back to the court.
Yes, Your Honor. I'll see if I can find out. I had to try and work this one on my own, so I'll try and figure out what the status of it is right now.
All right, so Mr. Guidry, just give me just a moment. I haven't received the paperwork yet that y'all.
Yes, sir.
Mr. Hartwell's working on that, so.
No problem.
Are you at a break in your trial, or is your trial going on as
we busted the panel yesterday, and we just put in our strikes, and the new jury panel was sworn in about 5 minutes right before you came on, Judge. So Judge told me, to go take care of you. So
Are you lead counsel or are you second chair?
Oh, I'm lead counsel, but we're done for the day. We got the jury sworn in, and they're coming back tomorrow at 9 o'clock. So we're good with that part. So Judge told me to come out and take care of business with you.
Okay, good. Well, tell him I certainly appreciate that. And who is
Yes.
that? Which judge are you before?
He's a retired judge, Judge Cupper.
Cupper. Okay, yes.
Yes.
Okay, good.
Andrew Cupper. Yes, sir.
Tell Judge Cupper I appreciate him working with us. If you want to.
Your Honor, So we did this all on Friday, so it may be, if it's in your queue, it may be as far back as Friday. Looks like maybe in the afternoon.
What date was Friday?
4:25, sir.
Yes, sir. You're correct. Thank you. All right, Mr. Ward, sir, if you will raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes.
All right, thank you. And Mr. Ward, can you see your attorney, Mr. Guidry? Can you see him online?
Yes, sir.
All right, excellent. All right, Mr. Ward, it appears that you were in this court on April 14th of 2022. You pled guilty to the offense of marijuana, possession of marijuana greater than 4 ounces, less than 5 pounds. The court heard the evidence and followed a plea agreement that day, and the court placed you on deferred community supervision for a period of 3 years and ordered you to pay a $1,500 fine. It was during that period of community supervision that the state filed its motion to adjudicate your guilt and revoke. They filed that on November 8th, 2022. And in that motion, they alleged what appears to be 7 separate counts of violations. Have you had enough time to review that with your attorney?
Yes, sir.
And do you have any questions about any of the paperwork that you've read over and signed today?
No, sir.
And are you pleased with Mr. Guidry and the work that he's done as your attorney?
Yes, sir.
All right. And Mr. Guidry, have you explained to your client his rights as they pertain to this case?
I have, Your Honor.
And do you believe that he understands his rights and that he's entering into this agreement intentionally, knowingly, and voluntarily?
Yes, I do, Your Honor.
All right. And Mr. Ward, I see that your plea agreement in this case, what you're asking the court to approve, is that you would plead true to the state's motion to adjudicate on counts 5, 6, and 7, with the state agreeing to abandon counts 1, 2, 3, and 4. And you're asking the court to adjudicate your guilt, convict you of the offense, revoke your community supervision, and assess your punishment under section 1244A of the Texas Penal Code, which means that you would be convicted as a felon, but you would be punished as a misdemeanor at 294 days confinement in the Van Zandt County Jail, in which you would receive credit for all 294 days of time already served. And you would be ordered to pay the balance of your financial obligations, which includes a $1,500 fine, $290 in court costs, and $655 in reimbursement fees. Mr. Ward, is that your understanding of the plea and what you're asking the court to approve?
Yes, sir.
All right, then, Mr. Ward, how do you plead to counts 5, 6, and 7? Are those counts true or not true?
True.
And you're telling me that those 3 counts are true because, in fact, what is alleged is true. You committed that violation.
Yes, sir.
And Mr. Ward, has anybody threatened you, forced you, or pressured you to plead true to those counts?
No, sir.
The court does accept the defendant's pleas of true to counts 5, 6, and 7. The court finds that the state has abandoned counts 1, 2, 3, and 4. Mr. Guidry, any objection to the court admitting into evidence the defendant's waiver of rights and plea of true?
No objections, Your Honor.
All right, that is admitted, and the court does take judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing further, Your Honor. Thank you.
Anything further from the defense, Mr. Guidry?
No, Your Honor.
All right, then, based on the evidence before the court finds that Ladary DeAnthony Ward has violated the terms and conditions of his community supervision. The court finds counts 5, 6, and 7 to be true. The court, based on that finding, adjudicates the defendant's guilt, revokes his community supervision, assesses punishment under section 1244A of the Texas Penal Code at 294 days confinement in the Van Zandt County Jail. Court issues credit for 294 days of time already served, and the court orders the defendant to pay the balance of his financial obligations. Mr. Ward, once you are released from TDC, then you need to, if you haven't already paid your fines, court costs and obligations, just because you go to prison when you come out doesn't mean that those are just wiped away. So you'll need to come to the courthouse and either pay those in full or talk to them about making a payment plan so that you can avoid being rearrested on failure to pay fines and fees. Do you understand?
Yes.
Okay.
Like you said, when I go to TDC.
Well, I'm sorry. You're actually getting time served and walking out. So whenever you're released from the Van Zandt County Justice Center, then you'll need to come over to the courthouse, third floor, talk to the district clerk's office, set up a payment plan, and then follow that payment plan. We'll work with you as long as you're making an effort to pay off these fines and fees, okay?
Yes, sir.
And I'm sorry about that. I probably startled you a little bit about saying TDC. So that's not the agreement. So, all right. So Mr. Ward, I'm gonna have you step over with the bailiff to be fingerprinted.
Thank you.
Thank you, Mr. Guidry. Let you get back to trial. Good luck to you, sir.
Thank you, Your Honor. May I be excused?
Yes, sir. Have a good day.
You too.
I believe Mr. Manning is ready now.
All right. Give me just 1 second. I've got to fill out this paperwork. All right, Mr. Manning.
Judge, ready on Mr. Solo James?
All right, DeSella James, CR 24-236. All right, what's your announcement today? I think we're here on motion to revoke.
Yes, Judge, we had a tentative agreement, however, received some new information today. I passed on to the DA's office. We'd request to set Mr. James for Thursday, so we can finalize our agreement with probation, make sure everything, all the boxes are checked for Mr. James to be successful.
Okay, any objection? State.
No objection, Your Honor. Thank you.
All right, you want this Thursday, Mr. Manning?
Yes, Judge.
All right, court will set Mr. James then for May 1st at 1:30. And do you expect it to be a plea that day, Mr. Manning?
That is my hope, Judge.
Okay.
Judge, next, ready on Mr. Spurling.
Eric Glenn Sperling, CR 22-157.
Judge, Mr. Spurling would like to set his case to Thursday for a plea. That'll be to TDC.
Right, court sets Mr. Sperling for plea on Thursday, May 1st at 1:30. All Who'd you like next?
Next ready on Mr. Tienda LaFlash.
Avery Clement. Is it LaFlash Tienda or Tienda LaFlash? My docket says LaFlash Tienda, but
It's Tienda LaFlash, Judge.
this is cause number CR 22-295. Go ahead, Mr. Manning.
Judge, we are set on a motion to revoke or motion to adjudicate where there's only one allegation. And at this point in time, in speaking to the state, there was no supporting evidence for that allegation. So we're asking for a reset so we can determine what we're going to do with this case at this point in time.
Anything else?
Yes, Your Honor, the allegation is a new charge out of Kaufman County. Want to get with Kaufman County and see what their plan is. I was able to get an offense report, but I'd like to see if they plan to pursue it or not.
You know how long that's going to take?
Shouldn't take too long, Your Honor.
All right, Mr. Manning, I'll set Mr. Tienda then, or Mr. LaFlash to May 29th.
And Judge, I just asked that I get a copy of whatever documents the state receives so I can go over those with my client.
I'm sorry, Your Honor.
He asked for you to disclose to him any evidence you received from Kaufman County so he can go over it with the client.
Yes, that should be in the portal. I think I put it in, should have been released yesterday, Your Honor, when I received it.
Did you hear that, Mr. Manning?
Yes, Judge, and I was out of the office late yesterday, so I may have missed it.
Okay. Who are you ready on next?
Judge, next ready on a plea on Mr. Marcus Turner.
Mr. Turner, this is cause number CR 21-343, State of Texas versus Marcus Darnell Turner. Mr. Turner, sir, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? I'm sorry, I couldn't hear you.
Yes, sir.
All right, thanks, sir. You can lower your hand. All right, let me see here, Mr. Turner. Stand by just 1 second. I've got to pull up the motion to revoke.
And Judge, he will be pleading true to all counts on that motion.
Thank you, sir. Mr. Turner, it appears that you were in this court on August 24th, 2023, and on that day you pled guilty to evading arrest or detention with a vehicle. Court heard the evidence and followed a plea agreement that you reached with the state. Court assessed your punishment at 10 years confinement in the institutional division of TDC. Also assessed a $500 fine. Court suspended the sentence that day and placed you on community supervision for a period of 4 years. And during that period of supervision, the state filed on July 22nd of 2024 its motion to revoke. And in that motion to revoke, the state has alleged 7 counts of violations. Have you had enough time to review that with your attorney, Mr. Jonathan Manning?
Yeah.
And are you pleased with Mr. Manning and the work that he's done as your attorney?
Yes, sir.
Do you have any questions about anything that you've read and signed today, part of this plea agreement?
No, sir.
Mr. Manning, do you believe that Mr. Turner is competent? Have you explained to him his rights regarding this case? And do you believe that he's entering into this intentionally, knowingly, and voluntarily?
Judge, he is competent. He has entered into this agreement intentionally, knowingly, and voluntarily.
All right, so Mr. Turner, I see that the plea agreement in your case is that you would plead true to all counts alleged in the motion. The state, upon that plea of true, would recommend to the court that the court revoke your community supervision and assess your punishment at 6 years confinement in prison, and along with ordering you to pay the balance of your financial obligations, which includes a $500 fine, $290 in court costs, and $155 in reimbursement fees. Mr. Manning, what kind of credit time is Mr. Turner entitled to?
Judge, Ms. Abney was able to come up with 397 days credit.
Is that what the defense agrees to?
Yes, Judge.
All right, so Mr. Turner, you would receive all of that credit time towards your sentence for the time that you've already spent in jail. Is that what you're asking the court to approve?
Yes, sir.
All right, so Mr. Turner, at this time, I would ask you, how do you plead to counts 1 through 7 as contained in the state's motion? And are you pleading true to each of these 7 counts because what is alleged in these counts is in fact true?
Yes, sir.
And Mr. Turner, has anybody threatened you, forced you, or pressured you to plead true to any of these counts?
Okay.
All right, the court will accept the defendant's pleas of true to all 7 counts as alleged. Mr. Manning, any objection to the court admitting the defendant's waiver of rights and plea of true?
No objection as offered.
That is admitted, and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing further, Your Honor. Thank you.
Anything further from the defense?
Rest and closure, Judge.
All right, based on the evidence before the court finds that Marcus Darnell Turner has violated the terms and conditions of his community supervision. The court finds all 7 counts to be true. Court will follow the plea agreement today. Upon that finding, the court revokes the defendant's community supervision, assesses his punishment at 6 years confinement in the Texas Department of Criminal Justice, and orders him to pay the balance of his financial obligations. Court awards Mr. Turner 397 days credit towards his sentence for the time that he's already spent in jail on this cause. Mr. Turner, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. I'm going to have you step over to be fingerprinted with the bailiff.
Thank you.
You're welcome, sir.
Judge, finally, I'm ready on Mr. Yarbrough.
All right, this is cause number CR 23-195, State of Texas versus Audie Bailey Yarbrough. Is this a plea today, Mr. Manning?
Yes, Judge.
Mr. Yarbrough, sir, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you can lower. All right, your name is Audie Bailey Elmo Yarbrough, is that correct?
Yes, sir.
All right, Mr. Yarbrough, it appears that you were in the court. Let me pull up your questioning. Yarbrough, it appears that you were in this court on February 15th, 2024 on the charge of assault causes bodily injury of a family member, a Class A misdemeanor. Court heard the evidence and followed a plea agreement in which the court ordered sentence at 1 year confinement in the Van Zandt County Jail, along with a $100 fine. The court then suspended that sentence pursuant to a plea agreement and placed you on community supervision for 1 year. It was during that period of community supervision that the state filed its motion to revoke on October 29th, 2024. And in that motion, it appears that the state has alleged 6 separate counts of violations. Have you had enough time to review this motion with your attorney, Mr. Manning?
Yes, sir.
Do you understand everything that you have read and signed today that's part of your plea agreement?
Yes, sir.
Are you pleased with Mr. Manning as your attorney and the work that he's done?
Yes, sir.
Mr. Manning, do you believe the defendant to be competent to enter into this agreement? And if so, Do you believe that he understands all of his rights that you've explained to him?
Your Honor, I believe he is competent. I believe he understands his rights and is entering into this plea intentionally, knowingly, and voluntarily. So,
All right, Mr. Yarbrough, I see that your plea agreement is upon pleading true to the counts alleged. The state's recommending that your community supervision be revoked, that your punishment be assessed at 288 days confinement in Van Zandt County Jail, for which you would get 288 days of time credit for time already served. In addition, you would be ordered to pay your financial obligations, including a $270 fine and reimbursement fees of $1,070. Is that your understanding, Mr. Yarbrough?
Yes, sir.
All right, understanding those things, I'm going to ask you at this time, how do you plead to all 7 counts as alleged? I'm sorry, all 6 counts as alleged. Are those counts true or not true?
True.
And are you telling me that each of those 6 counts is true because in fact what is alleged is true? You're not just saying that to get a plea agreement. Am I correct?
Yes, sir, you're correct.
All right, so Mr. Yarbrough, has anybody threatened you, forced you, pressured you to plead true to any of these counts?
No, sir.
All right, very well. The court will accept the defendant's plea of true to each count as alleged. Mr. Manning, any objection to the admission of the defendant's waiver of rights and plea of true?
no objection as offered.
That is admitted, and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing further for Your Honor. Thank you.
Anything further from the defense?
Question closed, Judge.
All right, then based on the pleas of true, the court accepts all 6 pleas of true, finds that those counts are in fact true. The court will follow the plea agreement today. The court revokes the community supervision of the defendant, assesses punishment at 288 days confinement in the Van Zandt County Jail, awards Mr. Yarbrough 288 days credit towards that sentence for time already served, and orders him to pay the balance of his financial obligations, including fines and reimbursement fees. So, Mr. Yarbrough, once you are released from custody, it's important that you report to the Van Zandt County District Clerk's office so that you can talk to them about either paying off your fines and fees in full, and if you can't do that, then entering into a payment plan so that you can discharge those. Failure to do so could result in you being arrested for failure to pay fines and fees. Do you understand?
Yes, sir.
All right. All right, you're hereby remanded to the custody of the sheriff so we can carry out the terms and conditions of the sentence. I'm going to have you step over with the bailiff to be fingerprinted.
Judge, I believe that concludes my business. May I be excused?
Thank you, Mr. Manning.
Thank you, Judge.
Your Honor, I believe Mr. White is ready.
Okay, I think I've got a little bit of a technical problem here. Abraham, if you get a chance, see if you receive the completed documents on Mr. Yarbrough. They acted like they were not going to process on my end, and it timed out and then the browser closed. So I just need to know if you don't receive those, then I'll need to go back in and re-sign them.
Yes, sir.
All right, Mr. White, who are you ready on, sir?
Yeah.
Are you ready on Mr. Williams?
Yes, sir, I am.
All right, this is cause number CR 20-276, State of Texas versus Justin Wayne Williams. Mr. Williams, sir, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, thank you. You can lower your hand. All right, Mr. Williams. Just 1 second here.
Your Honor, I'm also looking, because I don't recall having done a stipulation of facts for this case, and it is assigned to me.
I think this is a waiver. This is a plea of true.
Is it? Oh, okay. And I think I did sign off on that.
Oh, I have the documents. I just don't have the motion to adjudicate. It wasn't included in the paperwork.
Your Honor, this is a single issue. As I recall, I don't have it in front of me either, but it's a single issue MTA that had a allegation of a driving while intoxicated charge out of Wood County. Mr. Williams is being represented in Wood County by Brad Wilson, and I've informed Mr. Wilson last time I saw him over in Wood County of what we were doing with this.
Okay, very well. Let me see if I can pull the correct one here. All right, Mr. Williams, you appeared before the court on February 9th of 2021. You pled guilty to possession of controlled substance, penalty group 1, less than 1 gram of state jail felony. The court heard the evidence, followed a plea agreement, and deferred a finding of guilt, placed you on community supervision for a period of 2 years. And then during your period of community supervision, the court extended your supervision period for an additional 2 years. Through February 8th of 2025. The court also assessed fine of $1,000. It was during your period of community supervision that the state filed its amended motion to adjudicate and revoke on January 23rd of 2025. It appears that the state has alleged 4 separate counts of violations. Have you had enough time to review the state's amended motion to adjudicate with your attorney, Mr. White?
Yes, we have.
Okay, and are you pleased with Mr. White and the work that he's done for you as your attorney?
I am.
And do you have any questions about any of the paperwork that you've read over and signed today that is your plea agreement?
No, I don't.
Okay, and Mr. White, do you believe Mr. Williams to be competent to enter into the agreement after having explained to him his rights regarding the case?
Yes, sir. I believe that Mr. Williams is competent, that he understands his rights as they pertain to this case, and that he's waived those rights knowingly, intelligently, and voluntarily. Your Honor, I would note that court goes along with the plea agreement. Mr. Williams is being given a 1244A. I've explained to him that while he will be punished as a misdemeanor, that this will be a felony conviction and it will go on his record as a felony.
Thank you, Mr. White. Does Mr. Williams intend to plead true to all counts alleged?
Yes, sir.
And does he waive the formal reading of the amended motion to adjudicate?
We waive formal reading.
All right. And Mr. Williams, I see that the plea agreement you've reached with the state is upon you pleading true to these allegations. The state is recommending that your guilt be adjudicated. That means, as Mr. White has indicated, that you be convicted of the offense, that your community supervision be revoked, that your punishment be assessed under section 1244A at 90 days confinement in the Van Zandt County Jail, for which you would receive credit for 7 days towards that sentence. You would be ordered to pay the balance of your financial obligations. And you would also, you would be submitting to the jail today at this time for your sentence. Is that your understanding of the plea agreement, Mr. Williams?
Yes, I totally understand that.
All right, Mr. Williams, how do you plead to counts 1, 2, 3, and 4? Are those counts true or not true?
True.
And are you pleading true to all of those counts because what is alleged is in fact true?
Yes, I am.
All right, Mr. Williams, the court does accept your plea of true to counts 1 through 4. Mr. White, any objection to the court admitting the defendant's waiver of rights and plea of true in evidence?
No, sir.
That is admitted, and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor, thank you.
Anything further from the defense?
No, sir.
All right, then, Based on the evidence before the court finds all counts in the state's amended motion to be true. Court will follow the plea agreement today. The court adjudicates the guilt of Justin Wayne Williams, convicts him of possession of a controlled substance of penalty group 1 less than 1 gram. The court assesses sentence under section 1244A of the Texas Penal Code at 90 days confinement in the Van Zandt County Jail. The court awards Mr. Williams 7 days credit towards his sentence for the time that he's already spent in jail. The court will order that Mr. Williams serve his sentence beginning today. So, Mr. Williams, you're hereby remanded to the custody of the sheriff. Once you are fingerprinted and you are incarcerated, once you are released, I think there's probably a $70 reimbursement fee that you still owe. So when you get out, just make sure you come to the courthouse and check on your fines and fees and pay that off, okay?
For real.
All right, go ahead and go step over there to be fingerprinted.
Over here.
Schmidt.
We're ready on Fulbright.
I haven't seen the supplemental admonishments make it to me yet.
Judge, they were not, they're not part of the e-sign. I got them PDF and I'm able to e-sign them here. So we e-signed all 3 packets and I emailed those to Ms. Taberham's email. So that's where they're at.
Okay, all right, give me a second. Just stand by for just a second. Let me open all of these up.
Yes, sir.
You too. That's the whole.
I guess that would be here for a second.
All right, Mr. Schmidt, I'm ready when you are. All right, we are now on record in cause numbers CR 24-133, 2022-253, 2022-254, 2022-255. Cause number CR 22-214, cause number CR 23-138, and cause number CR 23-139. Mr. Schmidt also knows that there's a 2021-417 that's included as a 1245. I'm not sure if the court signed a order transferring that up. If I did, it didn't make the docket, but anyway, I'm gonna sign that today, but if it's still in Judge Winter's court, we may need to
Get it cleared up.
make him aware of that, make the clerks aware of it, so they don't carry it on the docket.
Yes,
All
sir.
right, Mr. This is State of Texas versus Zachorian Jure Fulbright. Mr. Fulbright, sir, raise your right hand. I'm gonna place you under oath. Sir, do you swear that the testimony you give to the court today would be the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir.
All right, you can lower your hand. Your name is Zachorian Jure Fulbright, is that correct?
Yes, sir.
And Mr. Fulbright, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No, sir.
In this case, you are represented by your attorney, Mr. Richard Schmidt. Are you pleased with Mr. Schmidt and the work that he's done as your attorney?
Yes, sir.
Do you have any questions about any of the paperwork that's in your plea agreement?
No, sir.
Mr. Schmidt, do you believe Mr. Fulbright to be competent to enter into plea agreements today? And if so, have you explained to him his rights as they pertain to each case?
Yes, sir.
And do you believe that he understands that he's entering into this intentionally, knowingly, and voluntarily?
Yes, sir.
All right, Mr. Fulbright, I'm going to kind of slowly walk through just because there's quite a number here. I want to make sure that I get all the correct information to you. It appears in cause number CR 24-133. You are charged with the second-degree felony offense of indecency with a child by sexual contact. And that's the same charge that exists in CR 23-138 and CR 23-139. The range of punishment for a second-degree felony indecency with a child by sexual contact is confinement in the Texas Department of Criminal Justice for not less than 2 years, up to a maximum 20 years confinement in each case. In cause number 2022-253, 2022-254, 2022-255, and 2021-417. Those are various charges from resisting arrest, search, or transport, failure to identify by giving false or fictitious information, possession of marijuana less than 2 ounces, and another possession of marijuana less than 2 ounces, all respectively. I see that part of the plea agreement today is for those 4 cases to be dismissed and considered as part of your plea in the indecency cases. Also, in cause number CR 22-214, you are charged with burglary of a building. That does carry a range of punishment as a state jail felony of not less than 6 months confinement in prison up to a maximum 2 years. Starting with that case, the burglary of a building, I see the plea agreement in that case is upon your plea of guilty. The state is recommending that the court convict you of that offense, assess your punishment under section 1244A, which means you would have a felony conviction, but you would have a misdemeanor sentence of 365 days in the county jail, which is the maximum you could have under a 1244A. You would receive credit for 365 days for time already served in that sentence. On the remaining charges of indecency with a child by sexual contact, I see that the plea agreement is upon your plea of guilty, the state's recommending that the court find you guilty and assess your punishment at 6 months confinement. 6 years confinement in Texas Department of Criminal Justice. No fine, court costs of $290, and reimbursement fees of $55. Mr. Schmidt, you probably have the paperwork there in front of you faster than I do. Is that the same plea in each charge of indecency with a child?
Yes, sir. The only distinction is the 1245 language in the the one offense. But it's only listed in that first one. Everything else is the same. In other words, the plea terms are the same. 6 TDC, no fine, court costs.
And what kind of credit time would Mr. Fulbright receive in each one of the indecency cases? And is it the same in each one?
No. And CR 24133 has 338 days credit. 139 has 414 days credit. 138, 414. And then he has, for the CR 22214, he has maximum credit.
All right, so Mr. Fulbright, do you understand the plea agreement in each case?
Yes, sir.
Is that what you're asking the court to approve today?
Yes, sir.
All right, so Mr. Fulbright, in cause number CR 24-133, cause number CR 23-138, cause number CR 23-139, to the charge of indecency with a child by sexual contact in each case, how do you plead?
Guilty.
In cause number CR 22-214, to the charge of burglary of a building,
Guilty.
and Mr. Fulbright, are you pleading guilty to all of those crimes because you are in fact guilty of committing those crimes?
Yes, sir.
Mr. Fulbright, has anyone threatened you, forced you, or pressured you to plead guilty to any crime today?
Yes, sir.
All right, the court will accept the defendant's plea of guilt in each case. Mr. Schmidt, any objection to the admission of the stipulation of evidence to support the plea?
No, sir, no objection.
The stipulation is admitted and the court does take judicial notice of the defendant's judicial confession. Anything further from the state?
Your Honor, in CR 22-214, there is a requested restitution hearing. I just wanted to bring that up. I think we'll be ready for the May contested, and that shouldn't interfere with Mr. Fulbright, the transport to TDC, given that it's 45, 60 days out these days. As for the 3 indecency cases, victims in all 3 cases are supportive, Your Honor.
Thank you, Mr. Harwell. Anything further from the defense, Mr. Schmidt?
No, sir. Did you want to set that restitution hearing date? I've got the.
Yeah, we'll,
complete your business.
well, let's go, we'll go ahead and complete it, but if you want to fill it out, we will set it for May 20th.
Thank you, sir. 29. Nothing further from the defense.
All right, then as to cause number CR 24-133, the court, considering the evidence, follows the plea agreement. The court hereby convicts Corey and Jeray Fulbright of indecency with a child by sexual contact, second-degree felony, assesses punishment at 6 years confinement in the Texas Department of Criminal Justice Institutional Division. The court will take into consideration with this plea under section 1245 DA unfiled cause numbers DA 2024-565 resisting arrest, search or transport, DA 2024-564 criminal mischief, DA 2022-1249 failure to ID, 2022-254 failure to ID, 2022-255 possession of marijuana less than 2 ounces, DA 2022-253 resisting arrest, and cause number 2021-417 possession of marijuana less than 4 ounces. The court assesses court costs in the amount of $290, reimbursement fees of reimbursement fees of $55. And in this cause number, court is awarding Mr. Fulbright his back time credit of 338 days. With regard to cause number CR 23-138, on the charge of indecency with a child bisexual contact. The court convicts the defendant, assesses punishment at 6 years confinement. The Texas Department of Criminal Justice assesses court costs of $290 and reimbursement fees of $135, and awards Mr. Fulbright 414 days credit towards his sentence for the time that he has spent in jail on that cause. In cause number CR 23-139, the court follows the plea agreement today, convicts Zachary and Jeray Fulbright of indecency with a child bisexual contact, assesses punishment at 6 years confinement in the Texas Department of Criminal Justice Institutional Division, assesses court costs at $290 and reimbursement fees at $115, and awards Mr. Fulbright 414 days credit towards his sentence for the time that he's already spent in jail on that cause. And in cause number CR 22-214 on the charge of burglary of a building, the court convicts the defendant of the offense, follows the plea agreement, assesses punishment at 365 days in the county jail pursuant to section 1244A of the Texas Penal Code, awards Mr. Fulbright 365 days credit towards his sentence for the time that he's already spent in jail on that cause. The court assesses court costs of $290 and reimbursement fees of $195. Does the reimbursement fee, did we assess the attorney fees for Mr. Fulbright under the 1244A at all?
Your Honor, I'm not 100% sure. I'd have to find the, dig into it to find the court costs.
All right, and pursuant to the plea agreement, the court is dismissing under section 1245 cause numbers 2022-253, 2022-254, 2022-255, and 2021-417. All right, Mr. Fulbright, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. I'm going to have you be fingerprinted, and we have set the burglary of a building for a restitution hearing on May 29th of this year at 1:30. Abraham, I'm just signing all these documents. Anything further to Jill?
Yes, sir. Would you, look at your phone?
Uh, no, we'll just wait. Let's just wait.
He wants to wait on federal papers out here, so.
Okay.
Okay.
Whatever everybody wants to do.
All right, court's going to stand in recess. We're now on record in cause number CR 15-152, State of Texas versus Maria Melissio. We're here today on the court's motion to adjudicate. And at our previous hearing, the court heard the evidence on the state's motion, along with arguments and evidence. In the court, at the conclusion of that hearing, found that Ms. Melissio had violated the terms and conditions of her community supervision. The court then set the matter for sentencing and ordered the probation department to create a pre-sentence investigation report. On behalf of the state, Mr. Hernandez, did the state receive that report for Ms. Melissio?
Yes, Your Honor, we did.
Do any requested redactions, corrections, modifications, anything of that nature?
No, Your Honor.
Mr. White, same question. Did you receive that? And there's any requests for additions, deletions, redactions?
Your Honor, I don't have any objections to the pre-sentence investigation report. I don't have any deletions. I do have a request. I have a couple of letters from members of the community that I'd like to include into the record as defendants, exhibits A and B. I'm going to offer those along at this time.
Is there any objections to defendants? Would you say A and B? A and B? Any objections from the state?
No, Your Honor.
All right, then defendants A and B are. At this time, would the state like to put on any evidence to sentencing?
Yes, Your Honor, if we may. First and foremost, I obviously would ask the court to take judicial notice of the record, its file, specifically the pre-sentence investigation report that the court has alluded to at the very start of this hearing.
The court will take judicial notice of all filings in cause number CR 15-152, which does include the pre-sentence investigation report.
Thank you very much. Your Honor, this, I believe, is a third time we were before the court on motions to revoke. Back on August 27th of 2015, she was placed on probation. And then she had her first motion to adjudicate filed on March 30th, 2016, placed back on probation on April 17th, 2017. Her second motion to adjudicate was filed on June 27th of 2017. And on August 24th, not even 3 months later, her conditions were amended and she was continued on probation. This third motion to adjudicate was filed on May 7th, 2018, and that's what brings us before the court. Your Honor is well aware the old adage is fool me once, shame on you, fool me twice. All right, I've given you a second chance. We're to number 3. It was somewhat disheartening, Your Honor, to read through the offense details, or at least the defendant's version that were provided in the pre-sentence investigation, because you really do want to root for somebody and hope that they've made it past their addiction and they're going to be in a much better place and they're going to be moving forward. Because according to defense exhibits A and B, both of these folks, Brad Lindsay and Ken McCormick, feel that that's exactly what Ms. Melissio has done. She has turned the corner, turned the page, as it were. But fact of the matter is, I think her offense details are most telling that she has not turned that corner. On April 14th, 2025, she was interviewed for this particular pre-sentence investigation. And her recollection of the events leading up to this arrest were completely different. She stated that she recalled being handed a pouch by Mr. Daniel Landaverde, but yet she claims that she was not aware of what was in the pouch at the time. She threw the pouch out and claims that she threw it out too late as the officer saw where she had thrown it, and ultimately she was placed under arrest. There was, I believe, in total, just over 3 grams of methamphetamine that was tested by the lab. Ask Your Honor to reflect back and take a look at entry 26, the written plea admonishments, and I'd also ask the judge, Your Honor, to take judicial notice of the fact that it used to be that the entirety of the police records were provided for purposes of establishing the factual basis for pleas. And I do have a copy of that, a certified copy. I provided a copy to counsel here. If I may approach.
You may.
And I did not mark a number on that, Your Honor. Is that going to be State's Exhibit 1 for purposes of this hearing?
I'm not sure if you offered anything in the first, let's just call this, states A.
That's fine. Thank you.
Mr. White, any objection to states A?
Believe that the state is asking you to take judicial notice of it. The court take judicial notice of its file, so we don't have an objection.
All right, court does take judicial notice and permits the certified copy of state's exhibit A.
Your Honor, so having stated the fact that the offense details as provided by Ms. Melissio were that she had no idea what was in the pouch, she had no idea what she threw out of the car, but yet we go back to 2015, the reason that brought her before this court. Investigating officer Landon Corbett states in his record that he asked her during the bookend process if she distributed or sold methamphetamine. And to that question, she answered yes. She claimed that the substance located was obtained approximately 1 week prior to the stop, and that the original amount was 8 grams, which means that at least 5 of those grams, Your Honor, would put back out into the community. Today, she sits before you asking for yet one more chance, but yet she has failed to comply with your judge's orders, failed in every aspect to really be a successful candidate for probation. We believe that she's earned her trip down to TDC, and under the circumstances, the only appropriate sentence would be a 5-year sentence. Thank you.
Thank you, Mr. Hernandez. Mr. White, would you like to put on any evidence at this time?
Your Honor, I'd like to call Miss Anna Melissio.
Is Anna Melissio? Anna Melissio, if you'll come forward, please. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, nothing but the truth, so help you God? Come on around, watch your step. That chair can move around so you can adjust it. Once you sit down, we ask you just move as close as you can to the front comfortably. And during your testimony, just speak up loudly and clearly so that everyone can hear you, and allow the attorneys to finish their question before you give the answer so that we're not talking at the same time. Mr. White, you're with us.
Good afternoon.
Good afternoon.
Now, we got 2 Miss Melicios, so I'm going to refer to you as Anna, if that's okay.
Yes.
Would you please introduce yourself to the court?
Hi, I'm Anna Melissio.
And how do you know Maria?
She is my oldest sister.
And where do you live?
I live in Houston, Texas.
What do you do for a living?
I work at Cypress Urology. I'm an appointment scheduler.
How long have you worked there, Anna?
4 years.
Do you have any children?
I have one girl.
Are you and Maria's parents still alive?
Yes.
Where do they live?
My mom lives in Edgewood, Texas, and my dad lives in Mexico.
And do you have the opportunity to see your mother in?
Yes.
And you're on good terms with everybody in your family as far as?
Yes, sir.
Yeah, okay. And do you have any other brothers and sisters?
I have 3 older brothers.
And what's the age difference between you and Maria?
I'm gonna say 5 years.
5 years? Okay,
Oh, 7 years. I'm sorry.
that's okay. We all have problems with math sometimes. Now, let me ask you, you were still in junior high when Maria got in trouble?
Yes. Yes, I believe so.
And do you really remember her getting in trouble?
No.
Now, over the years, have you had an opportunity to spend some time around Maria?
Yes.
Could you describe you saw how Maria was when she was not in a good way. Would that be fair to say?
Yes,
Did you know Mr. Landaverdi?
I did.
And did, do you know if Mr. Landaverdi and your sister had any children?
No,
You don't know if they did or not?
if they did have
They
children,
did have children, correct?
no.
Now, as far as Mr. Landaverdi goes, do you think he was a good influence on your sister?
No,
Now, did she have some things to do with some of her own decisions, do you think?
yes.
Since would you describe to the court some of the changes you've seen Maria make over the years?
Yes, as I was reflecting back, I've seen her have more motivation in life, um, wanting to do better for herself, her kids, our family. Um, um, and just
So you've seen her have some positive changes in her life.
positive changes, yes.
Do you think she's a better mother than she used to be?
Oh, yes, yes. I even asked her kids, and they completely agreed to me.
In fact, is she a grandmother?
She is.
And over time, you had spoke when we were speaking, you and I, you had mentioned that you thought that the light came back on.
Correct.
Could you explain that to the court? What you mean by that?
A lie as in like, it's like she like just woke up out of nowhere and realized, life is short. Like if I don't do something now, like nothing's ever gonna change. And me and her had a heartfelt conversation about you need, take accountability. Just look back at what you've done in the past and just from here on out, just move forward. And even though you've done what you've done or what the circumstances is, let's move forward and let's trust God and put everything on His hands.
You think she's got a good support system?
She does.
And that's with your mom and you,
Right.
your siblings.
Correct.
And you understand what, from our conversations, what you possibly, what your sister's looking at, right?
Correct. Yes, sir.
Now, I know the answer to this. Do you want to see your sister in the penitentiary?
No, I don't.
Now, you understand that's obviously a possibility.
Correct.
Do you think that if she was given another opportunity, that the changes that she's made in her life, do you think that she might have a better opportunity to be successful at?
Yes, I do.
And that's because, like you said, the light came back on.
Yes, she has completely more motivation to do better for herself and put herself in perspective and put herself first, love herself first. And she'll be successful.
Now, y'all, I guess, like a lot of families, had some family tragedies.
Correct. Yes, sir.
And do you think that those family tragedies affected Maria?
Yes, sir.
And of course, you know that Mr. Landaverdi passed away as well.
Correct. Yes, sir.
And do you think that, and I know this is hard to say that Mr. Landaverdi is gone, but do you think it's been beneficial for your sister to be away from Mr. Landaverdi?
Correct. Yes.
always hard on this. You had mentioned that your sister acted as somewhat of a role model in a way for you, right?
Correct.
But not in a positive way necessarily, correct?
Not necessarily, but there is some aspects she has. Yes, sir.
Like what?
Um, just the stuff that she's been through has made me realize, I don't want to be that way. So in my eyes, I feel like she was a great model by showing me, don't be like me, do better. And that now that I like knew better, I did better. And um, just everything that I ask of her, she's always has a positive mindset on anything that I need. So she's been a good
with
role
her-
model.
She's had, if I'm hearing you right, a positive effect on you, but she also taught you some things about not how to be.
Right. Yes, sir.
And I'm know that that's kind of a hard thing to say to your sister, isn't it?
Right. But
Do you
she
think-
knows.
Do you think that she's turned the corner?
Of course. Yes.
And do you think that she can be a positive role model to her children and to your child?
Yes, sir.
And you expect her to be, right?
Yes, sir.
That's witness young.
State your witness.
No questions, Your Honor. Thank you.
Thank you, Ms. Melissio. You may.
Thank you.
Step, please. Mr. White, any additional witnesses or evidence?
That's all we have.
All right. Mr. Hernandez, I feel like you've already made your closing argument.
Correct, Your Honor. Just rest and close.
Any kind of closing argument, Mr. White?
Yes, sir. Look, we all know how we got here. But I think one of the things we need to look is how we can go forward here. Regardless of what's occurred, the state has proven up one violation. And, I know, we all know what the law is and what the court can do on that. I would say that it'd be fairly highly unusual on one violation from 4 years before the expiration of the probation. To send somebody to the penitentiary over that. But I think what we're looking at here, when we look at it in total, is Maria has hurt herself. She's hurt her family. She hasn't necessarily maybe done the damage to society that Mr. Hernandez seems to think that she's done. It's hard to say because Mr. Landaverde is gone. But I don't think that there was any way that he was a positive influence. And unfortunately, sometimes people, when they leave your life, make your life better. That's a hard reality because people aren't ready to maybe do what's necessary or just can't. And in this situation, I don't see the utility in sending it to penitentiary. Court can do a lot of things. And what we do know is if she doesn't do it right this time, that there's going to be a very short leash and there's going to be no grace given. And if she's truly turned the corner like those close to her say she has, then she's got the opportunity to show the court and the community, but most importantly, her family, that she's the type of daughter, mother, grandmother, and sister that they all deserve. And maybe she's done things that legally would warrant having that part in her freedom taken away. But I think when we look at it, really what we have is somebody with a drug problem. And as a result, it follows all that when you read the PSI. You're around people you shouldn't be around to make bad choices. And sometimes people are ill-equipped to make the proper choices in their lives. And unfortunately, it takes time for them to come to that realization. And I think in this, if it was just a matter of punishing her, well then, okay, but it's not. And, you know, if the court decides to place her on probation, life's gonna be hard for her, and I told her that. We all know that. She's gonna be watched like a hawk. But I think not in every situation, but when you look at this in total, there are probably some things that Miss Melissio was going through that caused a lot of this. Now, obviously, she had a hand, but in this particular situation, I think that giving her that opportunity to show that she changed would be appropriate. And that's what we're gonna ask for to do.
Thank you, Mr. White. Anything from the state?
Your Honor, I resort back to the offense details. Everybody deserves a second chance. People deserve a third chance, fourth chance if they're moving forward. But as late as 15 days ago, Your Honor, she denied any involvement in this event. That's not somebody who's ready to look past this. That's not somebody who wants the help. Probation is for those who want to help themselves because nobody else can help them. She has earned her trip to TDC, Judge. Giving her one more chance is not going to do it. I wish I could be rooting for her, but I just don't believe that that's the appropriate thing at this point in this case.
Thank you, Mr. Hernandez. All right, court's going to take the evidence under advisement and the arguments. I'm going to deal with Mr. Vigil's case, and then we'll come back for the conclusion of sentencing for Ms. Melissio.
Your Honor, I was just looking at my tablet. I do have
Okay.
plea papers. So if I may step away with this.
Absolutely. Ms. Melissio, you can just stay right there.
The jail.
Idea. You just leave the field. Blocks out. Yeah. See it for Mr. Visual, so we'll just go on with Miss Melissio. We'll wait to see if that comes up. All right, we are back on record in cause number CR 15-152, State of Texas versus Maria Edith Melissio, attorneys for the state, attorney for the defendant, present. We're here in court today for sentencing. Court, having considered the pre-sentence investigation report, the evidence offered in court today, along with the testimony The court finds that Ms. Maria Edith Melissio, having violated her conditions of community supervision by failing to report to the Van Zandt County Community Supervision Corrections Department for the month of December 2017, which is count 4 of the state's motion to adjudicate filed May 8th, 2018. The court finds that Ms. Melissio is no longer a good candidate for probation. Court, considering the evidence that the May 8th motion to adjudicate was the third motion that was filed against Ms. Melissio, meaning that that was her fourth opportunity, or this being the third NTA, meaning that she had 3 other opportunities to avoid being handed down a prison sentence for her conduct, being placed on deferred adjudication in the original plea, and then having a motion to adjudicate in April of 2016 withdrawn in April of 2017. And then a subsequent second motion to adjudicate, having been filed in June of 2017, was modified and continued on community supervision with 70 days in jail as a condition of community supervision. Unfortunately, Ms. Melissio, I do not find that you would be a good candidate for probation at this time. So that leaves me with the only option of sentencing you to the Texas Department of Criminal Justice. Court, having considered the evidence, the original evidence that supported the plea, court finds that you possessed 2.63 grams of methamphetamine. Court, considering your statement to the DPS trooper that you were distributing methamphetamine at that time, but the court also taking into consideration the testimony that you've had provided on your behalf today, as well as the letters, character reference indicating that you have made a change in your life. The court hereby revokes your community supervision, assesses your punishment at 5 years confinement in the Texas Department of Criminal Justice Institution Division. Court orders you to pay the balance of your financial obligations. The court will give you your back time credit for all time spent in jail on this case. So I'm gonna have you be fingerprinted at this time. If you'll come forward with the deputy, he's gonna take your finger. Are remanded to the custody of the sheriff to carry out the terms and conditions of the sentence. Once she's seated, then Mr. Vigil, you make your way up. You want us to? Either way is fine. We are on record in cause number CR 21-00251, State of Texas versus Dallas, Anthony Vigil. Before you get started, the court had received the motion to arrest judgment and motion for new trial filed by Mr. White believe that was filed yesterday, correct, Mr. White?
Yes, sir, it was.
Court reviewed that and granted that motion without a hearing. Upon reviewing the original sentence handed down by the court did find that that was an illegal sentence based on the court placing the defendant on straight community supervision for an offense that was prohibited for a judge to grant community supervision on the finding and entering of a deadly weapon. So the court granted that motion to arrest judgment. The court also granted the motion for new trial, which gets us here today. And it's my understanding that upon that motion being granted, that, and the parties were in agreement with that motion. I like for the record to also add that today that there's an agreed plea recommendation on behalf of the state and Mr. Vigil, correct, Mr. Hernandez?
Yes, Your Honor.
All right. And so let me just state what that is before we get into it. I see that Mr. Vigil, who was originally indicted with aggravated assault and retaliation of first-degree felony, the recommendation today is for Mr. Vigil to plead to a lesser included offense of attempt to commit obstruction or retaliation, that being a state jail felony. And it appears that the recommendation is that Mr. Vigil be convicted of that offense and punishment be assessed at 334 days in the state jail division of TDC, along with a $500 fine. And I believe is Mr. Vigil entitled to 334 days, Mr. White?
That's correct, Your Honor.
In addition, Mr. Vigil would be ordered to pay a $500 fine, $290 court cost, and $185 in reimbursement fees. Is that the plea agreement, Mr. White?
Yes, Your Honor.
All right, Mr. Vigil, sir, just where you're at, if you'll raise your right hand, do you swear that the testimony you give to the court today will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir.
You can already hear. Your name is Dallas Anthony Vigil, correct?
Yes, sir.
Mr. Vigil, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Nolan White. Are you pleased with Mr. White as your attorney and the work he's done?
Sir.
Do you have any questions about any of the plea paperwork that you signed today?
No, sir.
Mr. White, do you believe Mr. Vigil to be a competent individual? And if so, have you explained to him his rights regarding the case? And do you believe that he's entering into this agreement intentionally, knowingly, and voluntarily?
I do, Your Honor.
All right, Mr. Vigil, you are charged by indictment with a first-degree felony offense of aggravated assault in retaliation. However, the plea today would be to a lesser included offense of attempt to commit obstruction or retaliation, a state jail felony, and that does carry a range of punishment not less than 6 months in prison up to a maximum of 2 years in a state jail prison, and a possible fine not to exceed $10,000. Understanding the plea agreement and the range of punishment, Mr. Vigil, how do you plead to attempt to commit obstruction or retaliation?
Yes, sir.
Are you pleading guilty to that crime because you are guilty of committing that crime?
Yes, sir.
Has anyone threatened you, forced you, or pressured you to plead guilty?
No, sir.
All right, the court hereby finds that Mr. Vigil's plea of guilt is proper. The court will accept his plea of guilty. Mr. White, any objection to the admission of the stipulation of evidence?
No objection.
Stipulation is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor.
Anything further from the defense?
No, sir.
Court will review the evidence. All right, the court, having reviewed the evidence, finds sufficient evidence to convict the defendant of the offense. Court will follow the plea agreement. Court hereby convicts Dallas Anthony Vigil of attempt to commit obstruction or retaliation, a state jail felony, assesses punishment at 334 days confinement in the state jail division of TDC, orders him to pay a $500 fine, court cost of $290, and reimbursement fees of $185. And the court awards Mr. Vigil 334 days credit towards the time that he has spent, towards his sentence for the time that he has spent in jail. This cause. Mr. Vigil, you hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. I'm going to have you be fingerprinted by the bailiff. Deputy Heisman.
I didn't have it. I was just for the judgment. Oh, yes, send it to Stephanie.
Do you, I believe that concludes the court's docket for today. I believe we had any names to call, correct, Ms. Grisham? I believe everyone was here. All right, court is adjourned for the day.